today, we'll be looking at the requirements of child maintenance under the law in Singapore. This issue may be especially relevant where couples are going through or contemplating getting a divorce. First, it must be noted that every parent has a legal duty to provide help with the child's daily living costs. The law of maintenance of a child applies equally to all persons in Singapore. There are two main categories of people who could be liable for the maintenance of a child. The first group is parents. Parents are primarily responsible for the maintenance of their child. This would include the child's biological and adoptive parents. This duty to maintain their child is present even when couples are no longer married to each other or when the child is not legitimate. The second group is non-parents. Non-parents would be subject to the responsibility of the maintenance of their child only if he or she had voluntarily assumed such a responsibility. A voluntary assumption of responsibility occurs when the non-parent has a family into which the child is accepted as a member. The non-parent can be the child's relative, foster parent, or even stranger, as long as it has been proven that there was a voluntary assumption of responsibility by taking the child into their family. It is important to note that the responsibility of the non-parent can be relinquished, but the court may find that the relinquishment of responsibility has not been proven satisfactorily. Unlike the responsibility of a parent, the responsibility of the non-parent is secondary. This means that the responsibility is imposed only so far as the parents of the child fail in their responsibility. Any sum spent by the non-parent in maintaining the child can be recovered as a debt from either parent. Additionally, the responsibility of the non-parent would come to an end if either parent takes the child away. Children below the age of 21 are entitled to maintenance. However, there are a few exceptions for children above the age of 21. Where the child has a physical or mental disability, where the child is or will be serving full-time national service, where the child is schooling or undergoing training for a trade, profession or vocation, or where there are special circumstances such that the court is satisfied that the provision of maintenance is necessary. Where the child is below 21 years old, the guardian of the child who has actual custody of the child may apply for maintenance for the child. Alternatively, the child's siblings may also apply if they are above 21 years old. When the child is at least 21 years old, he or she must apply for maintenance by himself or herself. There are a few factors the court takes into consideration when making an order for maintenance. The financial needs of the child, the income and earning capacity of the child, any disabilities of the child, the age of the child and the intended payer, the standard of living the child has been brought up to expect, the manner in which the child is expected to be educated and trained, the ability of the parent and non-parent who is being sued for maintenance to meet these needs. Among all the factors, the two dominant factors which the court considers are the first and the seventh. We hope that you have gained a better understanding of this area of the law. This was a project brought to you by AUP Law Corporation. For more information, do contact us or take a look at our related topics.